Both homework.
On Sunday I'll do the same thing, yeah, because I gotta do homework.
I bought their shirt.
You bought what?
I bought a shirt from there.
Oh, you bought a shirt for my W?
Yeah.
I wanted to do that, but the line's always so long, and I want to hold. I feel weird, like holding people up, like, hey, can I get a T-shirt?
I just grabbed it.
They used to only have like V-necks though, and I'm not a V-neck type of guy. I haven't tried.
It's a little more like your lengthy. It's a little more like the lengthy shirt type of thing. You know what I mean?
Yeah.
Like I bought it like, oh no. Let's go wear this at home. Yeah, like no.
Show some midriff.
I'm like nope.
I usually pull like the Britney Spears, you know, I'm like, grab this and like suck it through. No, you don't know it.
So I can totally see you.
Of course you could.
Oh, wait. Did they do it during the hypnotism?
Yeah, if they did,
Oh man, that'd be great.
I would have done it. Except you would be able to see my hairy ass belly.
Dude. Put it up there.
That's right.
And we'll get another water. No.
It's already 5:59. How? Lawyer sent us another email.
You did?
With the rule statements, yeah, that he wants us to like, it's MSJ, judgment is a matter of law, renewed judgment is a matter of law, and then motion for a new trial. And he just said this is what you need to memorize. Like, he's just so good about giving us, it's awesome.
So maybe we should ask questions about like writing essays because this Saturday was just like complete like we don't know what you're talking about, dude. You know, like he's like, oh, just put them all together. His MIs from the rule statements for blood.
Yeah.
I was like, so what's the SWOT strategy to like tackle this question?
You know, man, that was, I felt like last week we took a step forward, but
This week it's
this
just
week
like
we took like 5 steps back, yeah, it was bad.
Like, what are you talking about, bro?
Last week wasn't that bad, because he just went through the issues and we talked about them and he was like, I didn't feel like we learned anything because we looked at the model answer and
I just
said,
come early on Saturday. I told John, we know he's doing Felix, which is the comp. And I go to comp, so he's not.
yeah, we should talk to him,
Yeah.
but
He's like Harley in here.
I mean, he's a great guy, really nice. We're just on 2 different pages. We're on 2.
And I was talking to Connie about it. She's like, I just think he hasn't made the transition from this isn't a legal writing class.
Yeah.
This is, review substantive law for our
Right,
classes.
that's why we had it.
yeah.
I really didn't agree with him when he's like, I don't know if it's gonna get you more, but I don't think it's gonna hurt you. Well, like, but we're on the page where we're trying to get us more points, you know? You don't wanna leave anything.
Yeah.
Like, what the hell, dude?
Just some of them, I don't know if they're in the right order. That's what I want to for 2 weeks. Like, I had no idea, like, you guys have all the things off the right side, so I didn't even know what we did.
This since
Yeah. I know. I thought well, it wouldn't hurt to know what issues we were working on, and then because we had refreshing memory, so we started talking about it. Yes. Past recollection.
let's see. I missed the Vikings class. But you were here for that, isn't it?
It is hard to do.
It's actually,
Oh my god.
we didn't do exceptions. Was that the did we do exceptions? I think I did.
Yeah.
I did.
lateral support. And then hands in. Yeah. So we'll just. Whatever, right, just put that in.
Sorry, I was at a very loud movie. My ears are still peeling today.
It's all right.
I can't know. Damn kids, what you playing so loud for?
How was the VAP experience?
Pretty cool. I had fun.
You went
Where
VIP
were you?
something?
The art fight, the dome in Hollywood. I was in a band in 1983, very quickly, and we did a show in the desert, and I'm really amazing. No, I'm just kidding. And what happened was that they ended up doing a
No, I
series
have
of
one.
shows in like the desert. They actually didn't want to quite find it. And the thing is from these series of shows that the guy named Stewart did, the people that came to the show went on to start Lollapalooza, Burning Man, Coachella, and that's where all that comes from. Like going out in the middle of nowhere and just having shows. So I was in the very first band that ever played at one of these. So they found me and they said, "Hey, we're having the show. Can we, use your music and can we show your picture?" And I'm like, "How much does it pay?" "Nothing." "Okay." And I'm like, I never thought anything would happen. And when they called me back one day and they said, "Okay, we need you to sign a couple papers and here's your 2 free passes to the opening at the Art Light in Hollywood." And I'm like, so I got free popcorn. I got free Coke. And I did get 2 tickets in the middle of the theater. They gave me the 2 seats. So that was like the VIP treatment. And I also saw an enormous amount of people that I hadn't seen in 30 years. Most of them were bald now.
So that's good to know.
Yeah, so yeah, I'm still taking your calls. So.
You're not too cool for us now.
Hmm?
You're not too cool for us now.
Oh, that will never happen, my friend. Oh, indeed. So. I have to, one real quick thing, because when they heard that I was a law school professor, they fell off their chair. They couldn't believe it. And it's like, you? Fine. Right? I couldn't believe it, honestly. But when you grew up, working on
What did you play in the
it,
band?
guitar.
Do you still play?
Yeah, you can see me at this thing with John's birthday.
Oh, cool.
Yeah. Yeah, one of the types of music that I learned, that I learned first, which I really love, was surf music. So when he said playing a surf band, I was like, right on. That's very cool. But this band I played in was like a noisy, punky, kind of ratchet, that 80s sound. Yeah.
The garage band.
Yeah, kind of garagey, yeah. I mean, the whole thing, it's sort of like, we sort of moved sort of punk and then us and then grunge came next, so we're kind of in between and stuff like that. We all wanted to look like we came out of a French New Wave picture from the 60s. So the pictures of me are hilarious. I was looking at them and thinking, no wonder nobody liked me. I was just none of our friends are that. That's sad to find that out.
Okay, all right, so we've covered some different areas since the midterm, right? Excuse me for not being here for a couple of weeks, but part of getting ready for an exam, right, is determining what it is that we can test you on reasonably for an hour, right? Do you think that there are some subject matters that we've covered that maybe would not warrant an entire hour of exam response? Do you think there are some that may warrant at least an hour, right? So what are the major areas that we've covered since the midterm? Zoning, takings. Those are two very good areas that you should study in consideration of the midterm. Zoning and takings. We also did lateral and subjacent support, right? What else did we do?
Transactions.
We did nuisance and we did interest, right?
Nuisance,
See, oil and minerals.
right?
Yeah.
So resource interest effectively. What's the last thing we did?
Land sale contracts.
Land sale contracts, right? But we've gotten about halfway into those, right? That would be a little bit difficult to test. Not on the multi-state. Probably be more difficult to test on the written exam, no? Okay. So, that being said, when we're talking about mineral rights, I always want to have you guys thinking immediately, you know, we're talking about landowner rights effectively, and what's the theory that we use for landowner rights? General landowners. What land do you own?
Oh, the Arab.
Right, so heaven and hell theory, right? So that's how we get into, we may have an interest in mineral oil or, you know, natural gas rights, right? Because those can be sold separately of your actual surface rights, right? So you can sell the rights to the minerals under your, or in your soil and not sell them the actual physical land. You can, I suppose, have an easement or, you know, sell some right above you, but that's really fewer and far between because of the negative impact that would cause for, you know, running telephone lines, running, you know, commercial aircrafts, things like that. However, we'll get into aircrafts and how those can be affected. Because remember, we did some of those cases where they were landing like just above the chickens, right? So, and then they were freaking out and committing suicide or whatever it was that they were doing, right? And running into the wall. So, when we're talking about mineral rights, you are entitling a person, it's almost kind of like what we did before when you talk about profits. You are entitling somebody to the right to extract the mineral or resource from the land. Okay? You can lease it or sell it, however you want to manage that. So, when we get into the opposite area, when we get into, well, before I go from there, remember there are the laws of capture that we have, laws of reasonable use. So, remember the oil example, right? You have two people who live over a property where there may be a pool of oil underneath. And the law of capture effectively said if one person goes and sucks the entire thing dry, that's okay, right? That's kind of not in heavy favor at this point. They think more of a reasonable use. So then we saw the case where it said, you know, you could have up to whatever it was, 20 barrels. And then if you exceeded the 20 barrels, then you were exceeding the scope of your interest or something to that effect, right? So the alternative theory was rule of capture, where you basically go in and just take it all. Seems to fall in line with a lot of our original theories, like first in time, first in right, for riparian rights as well, right? So it's not unreasonable that that's the theory that they would have kind of originally had, but if you're looking at it in equity, it doesn't necessarily make sense, or realistically, it's just not fair to the other person, especially if they own the property above. Technically, that falls underneath their area, right? So something to be considerate of. When we start talking about airspace and air and sunlight, there really is no exclusive use to a landowner, because we talk about these things. There's commercial aircrafts, there's phone lines, there are other things that are going to be tracking over somebody's property potentially, right? That would make it economically inefficient if they had to have an easement or some kind of purchase of that property right. But this all kind of falls within the theory of the heaven hell theory, where you own everything up to heaven, everything down to hell. Now, there can be restriction on that, but the owners are entitled to freedom of excessive restriction, okay? Now, we started talking about situations where, you know, people were living adjacent to an airfield, right? And then that airfield kind of it was booming a little bit more than it was anticipated and began to develop. But then we're dealing in a situation where it's not just they're flying over us in our airspace, they were practically on top of these people, right? And so what did that case start to carry over into?
Nuisance? The takings?
Takings, right? Well, and arguably a nuisance because it was causing some friction for their animals and the chickens that they were breeding, right? So absolutely we start getting into the idea of taking. So let's put a pin in that for a second, but yes, that is where these things could cross over, right? And arguably it could cross into a zoning issue as well if that area is not necessarily zoned for what they're using it for, or maybe it was zoned for a small landing strip and now it's turned into a commercial use, okay? So that's where we started transitioning into the law of zoning and planning. This is a system of land use regulation which designates permitted uses for land based on location, right? So we see that every day when we drive by places, right? You're driving through, oh, residential. Are you going to see a gas station within a residential neighborhood? Hopefully not.
That's a slicky time.
Yeah. It's a little concerning, right? So generally speaking, these things are going to be zoned for certain things. You're going to have a commercial grade area like we do up the way over off of 42 and Golf Center, right? There's effectively warehouses that they've turned into shop fronts and things like that. Because everybody's been to TKB, right? Everybody in this room been to TKB. Yes? Okay, I was gonna get like slightly concerned. TKB? Oh my God, you're concerning me right now. Okay, we'll get you the free cookie on your first trip. It's fine. They will make all vegetarian whatever you want. Yes, it's amazing.
Okay.
Okay, so we've learned something new about Professor Drucker.
Wednesdays are the best.
Huh?
Wednesdays are the best.
Wednesdays are the best.
Except the barbecue days.
Well, that's not gonna help him.
Oh, that's right.
Yeah.
Ain't gonna help him. Come on.
Now
Did you fall asleep while I was talking about the vegetarian part?
Barbecue and Wednesdays are the
Come
best.
on. All right, but now I hear we've got CB barbecue Monday, Wednesday, Friday. I haven't been there, but I did have their food at a wedding that they catered, so I thought it was very nice. All right, so I digress. But zoning, so we've got different areas, right? We've got commercial areas, we've got residential areas. We touched on the constitutional aspects of it a bit as well, right? So, for purposes of zoning, bear with me for a moment. All right. This is pursuant to the police powers government may enact statutes to reasonably control land use. Now, we talked about areas, how they develop, how they evolve, right? So that's something where you might get into a variance. Does everybody understand what a variance is? Everybody? No? Okay. So when we talk about a variance, let me give you this example. A variance versus an amendment. Okay, everybody's starting to catch up? Okay. I know sometimes you hear these things and you go, well, couple it with something that's going to make me remember it. Okay. So a variance versus an amendment. A variance is going to be deviating from the given zoning law. That's your exception, right? So I'm going to use a contemporary example. Has anybody seen He's Just Not That Into You or read the book?
Yeah.
Okay, so the big joke is all women want to be the exception to the rule, right? But most of the time they're just the rule, right? That's how they play out the whole thing, right? And it's very cute at the end. The girl's like, I'm the exception, it's wonderful, and they make out, that's cute. Okay, great. So, this is the situation. The variance is the exception to the rule. We're going to allow the principal means to achieve flexibility in zoning. It's permission to depart from the requirement of the zoning ordinance, okay? There's a two-pronged test. You must show an undue hardship, and the variance will not decrease neighboring property values. These are typically granted by some governing board or administrative board, like a zoning board, okay? In contrast, or I don't even know that I'd say in contrast, the cousin to the variance, right, who's the rule, is the amendment. What they are asking for there is to actually change the zoning law. This doesn't work for us anymore, it should really be changed. Maybe the community has evolved. Maybe there's been some gentrification and now it's being used for a different purpose in that particular community. So we've got the variance to the zoning law where we're asking for an exception, and then we have the amendment where you're asking to have them actually rework the zoning law, okay? Does anybody have any confusion about that? Okay, now going into variance, do you think it is more difficult for the first person who is requesting the variance to get that granted by the board? Most definitely, right? There is strength in numbers in a variance. If other people have had it granted, you want to use that for your argument, right? There's been an exception made before, governing board. Zoning board, you know that you did it for so-and-so. Now here's another movie reference, right? Anybody Wedding Singer? Right, if you say, I don't even know what to say to you right now if you haven't seen The Wedding Singer. Okay, homework after midterms, okay? Not before, because I'm not unreasonable. All right, so, oh my God, I totally forgot what I was gonna say about The Wedding Singer. What were we just talking about?
The exception.
Variance.
First person, strength in numbers.
Oh my gosh, it just totally escaped me. Oh, no. I was saying it's good to have knowledge of the other variances and research that information to support your argument, because like in The Wedding Singer, where the lady who was the florist did not want to give him the good deal, and she said, I've never done a wedding for that cheap. And then he said, I know for a fact, and I think he dropped a little Easter egg. He said the Lemon Sol wedding, which is a name that he uses in a lot of his other movies, that you did it for Eric Lemonsol. So he used the previous variance or exception and said, now you give me the same treatment as well. I know that's a weird example, but now somehow you'll remember it. Okay, so the more times that there has been a variance, the better your chances are of getting the zoning board to approve. Now, the more times that there are a variance, you start getting closer to saying, maybe this isn't the best zoning law, right? So maybe we need to now transition and request that it be amended. Because if you've got 9 of the 10 people on the block that have already had this zoning variance granted, don't you think perhaps it's not suitable for that particular area? So now you're looking at maybe more of an amendment. So you're asking for them to change the zoning law or ordinance. In discussing zoning, we also talked about non-conforming use. So when we do that, the thing to remember is that this was a once lawful use that was existing that is now deemed by a new zoning ordinance to be unlawful, right? So you have to first make sure that they are using it initially as a lawful, currently as a lawful existing use, right? It was only because the zoning ordinance was changed that it became effectively unlawful. If you start as it being unlawful, then this is not a non-conforming use, it's just a violation of the zoning law. Okay, so it's really important that you at least hit that point when you are analyzing a situation where there may be a non-conforming use. Can it be eliminated all at once?
No, you have to give them like a reasonable period to.
Right. There has to be some kind of amortization period, right? So it cannot be eliminated all at once unless just compensation is paid, right? Because if it's eliminated all at once, what is it? A taking. So if there is no compensation paid, if it's taken, or if it's eliminated all at once, then this is a violation of takings. So what you're looking for are circumstances like the case where the daughter inherited the mobile home, but her position was it wasn't bought or sold, it wasn't transactional, it was effectively a circumstance where I inherited and just stepped into the shoes of the person that owned it previously. But they basically said any change in title would trigger the amortization period, right?
True, they did say that.
So I remember these things every once in a while. It's only been like a few years, so I figure I'll pick some up sometime. Every once in a while, I just get totally confused about something, and I'm like, I should know this thing, right? Okay, so if that's the circumstance, you're looking for that period of time that allows for reasonable transition effectively. If you don't, then you need to start getting into an analysis of it being a taking. Okay? So, the other thing that we talked about that was related to this was unconstitutional exactions, right? Yes, no? Everybody? Okay. I always use the example of when they built the Applebee's, and they say, okay, so an exaction are those amenities government seek to in exchange for granting permission to build. These are the Nolan and Dolan cases, right? So I briefed both of them in law school because it like seemed appropriate, right? So to pass constitutional scrutiny, and this is its own test, this is not some one of the 3 levels of scrutiny, the exaction must be reasonably related. Number 2, both in nature and scope. Number 3, to the impact of proposed development. So the example I typically give is when they build a new restaurant, like the Applebee's that's across from the courthouse. When they built that, you'll notice that there is a parking lot that is adjacent to it. Why? Because they border Highway 111 and then some small side street. And what they had there before was a bunch of dirt. So a lot of people would have crowded up the streets. You know somebody was going to try and pull up and park on 111 and obstruct traffic, and they just weren't going to be able to accommodate the number of people that intended to be patrons at that type of restaurant. So as part of this, do you think the city saying, okay, we will permit you to build this, we'll approve that, so long as you put in appropriate parking lot that can accommodate your patrons? Now we use that for the courthouse too, but you know, it's beside the point. So I think that's reasonable, right? Because you look at it, is it reasonably related? Yes, they need to be able to provide parking for their patrons, otherwise they're going to be stuck all up and down 2 blocks up the road. Is it both in nature and scope? Absolutely. It's within the scope of the business need and business use. To the impact of proposed development? Yes, because is it fair that the people who live on the next block over are going to have people parked in front of their house constantly trying to be patrons of Applebee's? Or that it's going to obstruct the roadway? No, not reasonable, right? What if there was a street sweeping day? Could the business not have people parked there? No. So that's one of the things that I think would have passed constitutional scrutiny for an exaction. It was a reasonable or constitutional exaction. Now, in evaluating that rule to pass constitutional scrutiny, ultimately what you have to say is this is either a constitutional or unconstitutional exaction. Now let me give you another example. What if they said you need to put streetlights adjacent to the building? How about sidewalks? I'd say so. If you're otherwise, what are they going to be doing? Walking in the middle of 111 trying to get up to the front of Applebee's, right? Okay, now, like one of our cases where the woman owned the hardware store, what if they said, we want you to rework the lighting for the 4 blocks surrounding your store? Is that fair?
No.
Probably not, right? It's not really their responsibility to rework the entire area. What if they said, we want you to do the parking lot adjacent to your building site. We want you to also do the parking lot or the dirt lot that's across the way. We want you to put parking there. I guess that's going to be factually driven, isn't it? Is that going to be used for parking as well? Do they have to purchase it? Those are other things you need to know about. So another exaction might be, okay, you need to go ahead and do new water main because you're going to be having a commercial grade sewage system. Maybe it wasn't previously zoned for that. Does that mean they need to do it all for the adjacent businesses as well? No, right? Not their responsibility. So these are going to be very factually driven. That's why you have to look at the nature and scope of the request, how it's related. Okay? Anybody have any questions about exactions? Okay. Effectively what it is you scratch our back, we'll scratch yours. It just has to be even. Okay? So when we discuss, because I think this is very related, takings, we got into, let's see if I think I'll just do that off memory. Okay. So takings we effectively discussed is going to be pursuant to the 5th Amendment, right? And it's expanded to the states by the 14th Amendment, kind of general concepts of constitutional law. What they are saying and the concept that we're trying to drive home is if the government comes in and takes your land for public use, now it's public purpose, it's got a little massaged around there, they must provide just compensation. Can they take it for private use? Ask Pfizer, right? Technically, that was a privately held company, I think, at the time.
Oh, yeah.
But they were providing a product that was for public purpose. That's how we started getting into this muddy situation of, is it public use or public purpose? Okay, so it's a little bit wish-washy there. Ultimately, what you need to look at is, has this property been taken in some way? And if so, has just compensation, taken for public purpose or public use, and has just compensation been provided for the taking? So it's really 2 points of analysis, okay? Now, just compensation is valued how?
Fair market value at the
When?
time of the taking.
Right. It is fair market value at the time of the taking. Do not forget to write that. You want to say they must provide just compensation. Just compensation is quantified as the fair market value of the property at the time of the taking, right? Because then what do we get into? We get into that Yahoo who's like, hey, you owe me $6.5 million or whatever the circumstance was, because if I had finished building this and I rented all my units or sold all the units, that's how much I would have made. Okay, well, how much are you into it at this point? I spent like $5,000 on an architect to draw me up some plans. Well, look, I don't want to throw away $5,000. But you certainly don't get 6.5 million. I don't think it was really that high. I know it was much lower. But just for argument's sake here, it's just so disparate from what had actually been invested. Of course, this guy's thinking, I bought this on the basis of being able to do this, right? Because that was a zoning ordinance that changed, right? See how takings and zoning ordinance can cross over real easy? So let me have a general concept now that we know the rule of taking, right? We have two types of takings, right? We have actual or physical takings, and we've got regulatory takings, okay? So effectively, I know I have notes on this, I'm sorry. Bear with me for one moment. I just want to make sure I don't miss anything. I even know where they are, like on the page, but.
Yeah, because if you do get a takings question, they're really not, let's be blunt, they're really not that hard.
So you better hit all the points.
You better really hit the points. Because every time something's missing, you see how it looks bad if you skip over things in the takings question? Because it's like a chain. You just go kind of 1 to 2 to 3 to 4, and then it's sort of like 1, don't stop going, 2, that kind of thing. And so the takings questions, the zoning as well, I think it's fair that we really expect to see a well thought out, not only the correct issues, but the correct issues in the correct order. Because you can't really do them out of order. You try to read the paper, it looks weird. So again, taking good to get because they're not terribly difficult. On the other hand, you do have to be fairly precise in them. Also, should you get a takings question, or what do you think the chances of a straight actual taking would be? So think about that.
Be prepared for what it can cross over.
Yeah, think about it. Yeah, it's a physical taking, great. 90. Right? So chances are it's going to morph into something, and you can kind of see how that's not very hard. They really are very much connected with most governmental functions. Most things that happen at the city council level, things of that nature. So that's just, and they tend to go together. If you start reading articles about takings, you'll see that they always go through a great number of issues, including zoning and things of that nature. They're always kind of tied on to that. There was I still remember many years ago when they were building the 105. I remember a time there was no 105 freeway. Can you believe that? And I remember when they took the land. It was a bunch of old, unfortunately, it was a very depressed area. And there was a whole bunch of these really old homes. And you could still drive through the 405 and you could look down and you saw this ghost town that, went out as far as you could see it. And then within a couple of years, there was this, shining new freeway we call now the 105, which went all the way to the ocean. Woo! But it was really just this amazing, thing to see. And, I don't really know why, but I remember my dad drove off the freeway for some strange reason. And so we're just driving through this area of town where there's nobody there. There's all these empty houses. Some of them are boarded up, some of them are on. This is back in the day, and believe me, there was still plenty of graffiti all over them. It was really quite something to see, Anyways, so.
Well, you bring up a good point. I don't want you to forget when you talk about zoning, the idea of racially discriminatory zoning,
Indeed.
right? And so what that triggers.
Very easy to cross over.
Yeah,
too.
And it's a very easy con law crossover when you kind of get more developed in that area. So when we talked about racial discrimination and zoning, you get into what's going to trigger government action that makes it a violation of the 13th Amendment. And that's going to be somebody trying to enforce a racially discriminatory zoning law. Because as soon as they try and enforce it, the court gets involved, right? Now you've got government action. So I know we didn't really delve too deeply into that, so I won't make you too concerned about that.
But be aware of it.
But be aware of it for multi-states.
Oh, for sure.
So again, taking clause, Fifth Amendment provides for the provides that private property may not be taken for public use without just compensation. Public use, you need to look at it on a rational basis theory, right? Is it rationally related to a legitimate public purpose? So health, safety, welfare, economics, or aesthetics. So, now in discussing takings, again, okay, so you've got your main rule, you now need to identify whether or not it is an actual physical taking or a regulatory taking. A physical taking is just that. They've come onto the land, it's more of an eminent domain kind of situation. We are taking this land for our use, right? And you need to look at some categories of physical taking, right? Is this a complete or a partial taking? Is this a permanent or a temporary taking? Those are areas you need to analyze. Why? Because you have very different ways of resolving what just compensation would be depending on what those factors fared out, right? You've got the one lady who's got a cable run up the side of her building that nobody really noticed and isn't really negatively impacting any of the use of the property, but it is in fact a physical invasion. That is an actual taking. But, and I suppose you could arguably say it's a permanent taking because they have fixed it there and there's no end date. There's no end date in sight. It's intended to be an indeterminate amount of time, right? So you can argue that that's a permanent taking. But what did they ultimately decide in that case? Nominal damages, right? How do you quantify using a half-inch outside of the building in an area that's not otherwise, I mean, like, unless your buddy's a Spider-Man and that's his, like, primary area of getting in and out of the building because he crawls up that area and he's getting caught in the cable, like, how's it going to negatively impact you, right? So they basically said, all right, like, here's some bucks, but it's going to be minimal, right? So you need to look at those factors versus somebody who has them come in and say, we're going to build a wall on your land. All these lovely people in the bordering areas that are like, yeah, wall. And then they're like, oh, but you want to do that here. My house is there. That's a problem, right? So now it's like, great. And I will cheer you on from not my backyard because it's your backyard now. And that's where the wall's going. So realistically, if they're going to come and take the land and it's effectively going to take your entire property, you need to say it's a complete taking, right? Now, that arguably is going to be, not arguably, that's pretty much a permanent taking, right? Versus maybe they came on and took part of your property because they were expanding something, or like in the airport cases, right? They're flying over. Couldn't you argue that that's a taking? You should argue that that's a taking if it meets the right factors, right? Because what did we say about airspace? This is where the zoning law crosses over. Airspace, you are not entitled to exclusive use of your airspace, but you are entitled to reasonable use and not have people, what was the term that was used? Freedom from excessive restrictions, right? So something to be mindful of there. Now, what if they expanded and took part of your property because they were expanding the landing strip? Partial taking, but maybe that completely affects your use of the property.
Okay. Yep.
So you need to consider that. So, does anybody have any questions about actual physical takings? Okay, now let's talk about a regulatory taking. Regulatory taking is going to be something that effectively causes your land to be unusable as a result of some regulation that has been put into place. So, maybe it's something to protect the marshlands. And they say, okay, now you can use it to have a picnic on. but nothing else. So you've got, maybe water adjacent property that now you can have a picnic on. Do you think the value of that property was negatively impacted? Yeah, absolutely.
And just to show you how this works, there was just an article the other day in the LA Times that down in the South Bay in Los Angeles, that marsh area they have down there, that's right next to Playa del Rey. I mean, this is like on the beach.
This is like prime real estate.
Prime real estate. And it's a marsh. And so Steven Spielberg, I think I might have mentioned this before, that was his original spot for DreamWorks. And he bought the land and they told him, Mr. Spielberg, we hope you like your marshland.
Yeah.
And he was forced to sell it. They wouldn't let him build there.
What do you think he sold it for? Probably not as much as he purchased it for.
Yeah, he took a bath on that one, but get this now. These really rare owls are now there. And now they're thinking about making it an endangered species habitat. And the builders are going berserk. And they want to build houses on the beach.
Well, there's
Too
limited
bad.
space, right?
Stand with the owls. Yeah. All right.
Yeah.
What about the tar pits? What's that story? Because I'm not from California, the Brea tar pit.
Yeah.
How did that end up?
Never been there.
Oh,
La Brea Tar Pit, never been.
I've been there several times.
Nope.
It really is a tar pit
Yeah.
that they found, and they're all fenced off now, and that's where they go. And why they're so famous is because they mine dinosaur bones out of them, because the dinosaurs what would happen is when it rained is like they would get covered with water. And so the dinosaurs didn't realize there was tar underneath, and so they'd walk out into the tar pit. And if they stayed there too long, the tar would attach to them, and then they'd get dragged down into it. And so that's why
Terrible way
it's
to die.
famous. Yeah, really awful. They've got these exhibits, and it's like, try to pull yourself out of tar, and you
I know.
can't do it. It's really
You're struggling, bro. I'm sorry.
I know, it's up for coffee too.
Anyway, this is really cool. If you ever go there, the museum's really, really neat. Yeah. There's also rumors that, it's highly possible that, Jimmy Hoffa might be. It's very cool though.
I always think of that case, from Orange County where the lady, I don't know if it's her husband or boyfriend but the police were investigating the guy's death and she had cooked him.
Jesus.
And I think he was on the pot on the stove
Mhm.
when they were there. I don't know that she fed him to them, but I think he was being cooked.
There was a movie about what is it called, Green Onion?
Oh, was it something similar?
Years back in the 70s,
Oh, yeah.
when they cooked, they would do,
Ooh,
they murdered them and they cooked them.
yeah, that's awkward.
Oh,
Ugh.
Yeah, I can do that.
So, wow, that's
How
a
do we get
weird
on
turn.
this?
I have no idea. Okay, so regulatory takings. It effectively makes something, there's no economically viable use of the property. Now that cannot be, excuse me. Now that can't just be a diminution in value. That has to be no economic use of the property. So just because it makes it less valuable doesn't mean that you're gonna fall into regulatory taking status, okay? But if it creates a circumstance where it effectively makes your land economically unviable, then you can argue that there's regulatory taking. You need to still address the two-part issues of the taking, and then you need to address what the fair market value would be. Now, fair market value at the time of the taking, well, I'm certainly gonna be arguing this is what it was up until the taking, and they're gonna say, well, considering the taking, here's how much it would be worth, right? Right. So, again, identify that the Fifth Amendment is what governs the takings clause, identify the rule for the takings clause, identify whether or not it's an actual or physical taking. That is not two different things, by the way. I say that as a actual / physical taking, or a regulatory taking. So two types, right? Now, if we're gonna go into actual or physical taking category, you need to talk about whether or not this is a complete or a partial taking. And then you need to talk about whether this is a temporary or a permanent taking, because all of that will affect the argument related to what?
Just compensation.
Just compensation, right? And just compensation is defined as what?
Fair market value at the time of taking.
Correct, okay? Which is what you're going to highlight under your just compensation section, right? So that's how we go through the list there. Now, arguably, if you have a regulatory taking and there's a zoning crossover, it could be because of the zoning ordinance. That may be the regulation, right? Versus a physical taking where maybe it's still a zoning crossover, but they zoned it for different use. Right? So, if you have a regulatory taking, again, it's going to be a regulation that effectively makes your property
Valueless.
that's a good way to put it, right? Economically unviable. And as a result, your interest in the property has effectively been taken from you, right? Your use of the property. That, again, does not mean a diminution in value. Well, I mean, it does mean a diminution in value, but you have to get so low for it to really qualify, right? This isn't, it's just not as valuable as it used to be. This is like a significant, like, we are 90% down from what the fair market value was before this regulatory or regulation was put in place. So I can't give you a hard number to use, but I would say it has to be, it's kind of, you have an abiding conviction. Anybody ever read what reasonable doubt is? We always explain it's an abiding conviction, right? So it's like, it has to be so far down the road that you are virtually almost to completely economic unviability. So again, I can't give you like a percentage that would cut it off, but it's got to really be close to being economically unviable. Versus, you guys know what preponderance of the evidence is, right? Right? So just slightly tilt the scale. That ain't gonna qualify here, okay? I don't even think clear and convincing evidence would work. I think this is more of a beyond a reasonable doubt kind of analogy, okay?
Pretty close.
So, yes.
One more time. So when we get a takings question, so we start off the first ladder, regulatory versus actual physical.
No.
No?
You're going to address takings and which amendment it comes from, and then the rule for taking.
Right.
Then you're gonna identify whether it's an actual or physical taking.
Oh.
And then if it's an actual taking, you're going to go full or partial. Then
Temporary.
then temporary or permanent.
Okay.
And yeah, and then regulatory is going to be a separate approach, effectively. You want to say takings can be both actual or regulatory, and then identify which one it is. Then for regulatory, obviously, you're going to want to tell me what?
Public purpose or public use.
Before that. If it's a regulatory taking, what are you going to tell me?
The regulation.
Yes, the regulation.
I know.
Tell me, just literally put it on there. Here's the regulation that was implemented. Here's how it affects, right? Because you're going to have to talk about the economic viability of the property. And then you're going to talk about, for public use, public purpose, and then you're going to talk about just compensation.
So for regulatory, do we not talk about complete and partial, or? Because technically, I guess it could be a partial taking.
I suppose it could be, but I think more of a regulation is going to be something that affects the land as a whole. I don't know that I've seen a partial regulatory
I mean, it's
taking.
it's theoretical, but yeah, I can't think of a case off the top.
I can't think of an example that I would give for that,
So
but yes.
instead of doing
Yeah.
the approach that we do for physical taking, we instead talk about deregulation.
You address the
How ours-
actual regulation and how that's affecting the property and the economic use of the property.
Okay.
So yeah, no, not really because I think any regulation is going to affect the land as a whole,
I would think, oh, if you lose half your land.
but what would be the regulation that would
And what
affect
would
only
do it?
half the
That
land,
would be
right?
Pretty weird, yeah. Yeah, I mean, I can't say theoretically, because you know.
That's a
it's not
physical
law, I
taking.
mean, anything can happen.
Interesting that you say that. He said the wall, and no, that's a physical taking. Because they're actually physically encroaching, invading is a better word, your property. So, everybody okay with that?
And public use and public purpose, is that just for the regulatory taking or? is
No,
that for
that's the
both?
rule for takings.
The rule, okay.
Now, so effectively before, it had to be for a public use, so it couldn't be, go look at the Pfizer case. Because in that case, I don't think it's called the Pfizer
Kilo.
case, Kilo, sorry. So go look at Kilo, because what ends up happening there is, that's where you start getting into them waffling on public use. Before it was, it's taken from a private party for public use. Well, you couldn't just stroll into Pfizer and start using it as a private citizen. So, but they said, our use of this land is going to allow us to create jobs for the community, which is going to help reinvigorate the economic nature of the community. And it's also going to help us produce these medications that are going to be for mass use. And so it is a public purpose that we are benefiting the community as a whole, right? Versus we couldn't just like stroll in and be like, hey, I want to make my own drug and a little this, little of that. They weren't allowing people to just, enter freely. So it's not really for public use.
Yeah, I mean, it
But
wasn't,
good questions, yeah.
it was a building, business building,
Yes.
complex. That's true.
Okay, so I think all we have remaining is land sale contract?
Question.
Yes?
Okay, so I remember there was a case where they talked about like the expectation.
That's
Yeah.
How would you incorporate that because you said that, there was the argument that he's like, I bought this land thinking it was gonna be of this value.
Because you're gonna look at that's what I was saying, I can't give you like a hard and fast number. So, because
Plus Penn Central's weird, right? I mean, we're talking about
That's
Penn
what he said,
Central
yeah.
now. So it doesn't fit well with everything else. But
it doesn't fit because what you're saying is, are we going to be rich or are we gonna be uber rich? Which is part of the argument that they had was, like, you're gonna have, well, I don't know if this is a good example. You're gonna have an M in front of your money instead of a B in front of your money. Does that make sense? You're still gonna be really wealthy and get a lot of return from this. You're just not going to get as much as you wanted.
And that only applies to a regulatory takings analysis or to both?
Well, I mean theoretically.
No, it's really more of a regulatory taking approach.
Yeah.
Okay.
Because
Yeah.
it's not so much in a physical taking, they took it.
Mm-hmm.
It's we have invaded your property and taken a piece of it or all of it. That is not really in dispute that it's taken. In a regulatory taking, the dispute is factually driven of, well, we just created this regulation. Nobody's physically invaded your land. Your land is effectively unusable for what you intended, or it changes the makeup of what you can and can't use your property for. So that's why it's really more of a fact-driven circumstance. It's kind of like going a specific versus a general intent crime.
Okay.
It's just much more factually driven when it's specific intent, right? Now, that being said, in Penn Central, you've got a circumstance where they basically can still use it, they can still make money off of it, they just aren't making
Right.
as much money off
Right,
of it.
remember in Penn Central, it was profitable. They weren't losing money.
I still disagree with that case, if it makes anybody feel better. I think we live in, it's capitalism,
That's a good
right?
argument.
Yeah, I last year I got a little up in arms about it. I don't think I was here when you did Penn Central this year. That's why you guys didn't see me get all worked up. I think if you work hard and you go buy something and you want to develop it and it's within reason because they had all the other buildings that were surrounding that effectively got to do what they didn't get to do, right? I should be able to go and develop that. They weren't asking for anything unreasonable. I think they were asking for less than some of the other surrounding buildings were going to build up. And so they just said we wanted, what was 11 stories?
No, it was like 55.
It was quite a few
Was
stories,
it, but something else was, maybe something else was 11 stories higher than it? I don't know
there
why I
were
always thought
buildings
that.
that were just as, I mean, they weren't
Right.
asking for the, they weren't asking for Trump Tower on top of the Penn Central.
Well, because they had the Pan Am building that was,
The Penn Am building was right.
Yeah, he showed us the
behind
picture
them.
right after the case, and I'm just like, oh.
right, so it's kind of like, okay, why can they do it, but we can't,
But
right?
audio visuals this year.
Oh, did you?
Yeah, so we'll do it next year.
Totally missed that.
Yeah,
So
you can
sorry.
see where it was gonna go and.
I'm such a geek,
Yeah.
but I have good hair, so it's okay. All right, it's a little wonky right now, so don't judge me. All right, so in that case, I don't like that case because I think they should have been able to build like they planned, like the other buildings got to do. And I think the regulation was effectively, the problem is it reduced their economic viability, but not so significantly that it was economically unviable. You get me?
Yeah.
So, like I said, they've got a B in, or they've got an M in front of their dollar description instead of a B. Apparently they were no Kylie Jenner, right? Sorry, well,
You do know that the first episode of the Kardashians' new season is gonna be about the house that Kylie Jenner just bought here? I just read that. Yeah,
oh Jesus.
I didn't even know who she was till I saw that article, to be honest with you. It's like, who's Kylie Jenner? She's a Kardashian.
Self-made.
That's the hard part. That was the controversy, self-made. I mean, I think you should say thanks to your
Yeah,
sister.
what color would you like, Kylie? Blue. Good call, yeah. Good call.
Hey, whatever, she's laughing all the way to the bank.
Yeah.
All right,
She put me in her role if she wants.
so we've got now the last area that I don't think I missed anything, right? We've got land sale contracts, right?
Wait,
Yes, ma'am.
I'm sorry, go ahead.
We're not gonna do nuisances off the table as far as.
Oh, no, sorry, I should go over that as well. My apologies. I did have that set aside and then I put it away, so I thought I'd already done it. My apologies. Okay.
Yeah, also for Penn Central, by the way, let me just, unless you see really very specific facts, something like, but I bought the building expecting that I would, on the reasonable expectation that I would be able to profit, right? That I would be able to build something on this, things of that nature. So if you don't see those facts, I can't say if it's about economics, it's not worth giving it a nod, but don't get into this big analysis and never ever say something like, well, if they were to build on, see, that's not what it means. I mean, you have to sort of make the investment with the idea that you would not only be able to profit as, because you want to buy a profitable business, but that you bought it with the distinct expectation that you would be able to, make more profit. So you have to see very specific facts to really get into a detailed analysis of Penn Central. But it is good law, and if it's, about economics and things, depending on the situation, I would definitely throw in a line about it. But don't get too crazy. It really needs very specific facts. Yeah?
Okay, so by the way, I just found my notes on takings. It's right under nuisance, so good looking out. All right, just to make sure that my verbiage was correct there. Possessory or explicit taking, so actual or physical taking is an act of government condemnation, right? Eminent domain. regulatory or implicit takings, a government regulation that leaves no economically viable alternative, an economic upset of your investment. It has to be a significant economic upset, okay? It can't be that it just was a slight diminution. All right, so for purposes of, we kind of did trespass, invasion of land by tangible physical object, possessor may seek an action in ejectment or removal of the trespasser, right? Everybody know what ejectment means? Everybody have a VC? Okay. DVD or VCR. I realize like this side of the room, DVD, like you too, but maybe VCR. I did fall into the Betamax, so I'm in the VCR category, okay?
I started with VCR, right?
Right?
do.
By the way, like this close to Coachella, I have to be careful with the VCR references. No? Anybody? Mario Coachella Rifa? No? Okay. Which is funny that they use a V. It just, yes! I'm like, Mario is spelled with a B. Why do you use a V? Anyway, sorry, it's a little game reference.
Okay.
May or may not have had some clients from the area. All right, so then we get into nuisance, right? Private nuisance, substantial and unreasonable interference with another's use or enjoyment of the land. Doesn't require tangible or physical invasion. No. Odors and noises are sufficient to give rise to a nuisance claim. But does a hypersensitive plaintiff prevail? No. Right? This is really more of an objective standard. It's not going to be on the basis of the hypersensitive. So I always say, anybody watch Friends? Oh my God, you're like killing me tonight, bro. Oh,
Why? She hasn't seen the wedding singer.
she just,
I love
fair
Friends.
point, well made.
I love Friends though.
Fair point, well made. Okay. So they had this guy that lived downstairs. I can't think of his name. Oh my God, I'm terrible.
I thought you were a fan.
Oh my God, I know, it's so bad. Okay, this is like what Bobo called the Howard Stern show and claimed to be the biggest fan. Anybody who listens to that would get that reference and maybe.
Love the Howard Stern
Okay,
show.
there you go. I got one. All right. So he is downstairs and he constantly hits the ceiling with a broomstick because he's just everything. But I mean, they're like barely walking and like barefoot, and the guy's like, "Stop making noise!" freaking out, right? So I had a client who was alleged to have done that too in a 2-story apartment building. It's weird. This stuff actually happens in real life. So this is the hypersensitive plaintiff, right? That doesn't get much play in the court. It's got to be more, it's more of an objective standard. You know, would a reasonable person be negatively affected by this? Distinguishing private versus public private doesn't mean that it's only one party. Private just means that it's maybe more of a cluster of people or an individual. Public means more, you know, kind of a community as a whole. Does that mean the entire city? No, it could be an entire gated community. You know, it could be Sun City, right?
Possible. Yeah.
And the other thing that we talked about when we talked about nuisance was coming to the nuisance, right? So it's really more of a kind of tort-driven case, right? So when you're coming to the nuisance, does that affect your argument, right? You're essentially, there's no mitigation of your damage because you're effectively throwing yourself into the nuisance. So how does that impact you, right? And that was Del Webb. And that was actually a Sun City
Sun City.
property as well.
Yeah, that was one of the first Sun Cities. It might have been the first one.
Huh.
Now we're getting, you guys know we're getting another Sun City. Read about that.
Really?
Rancho Mirage.
Interesting.
One's coming to Rancho Mirage.
By the casino? Like across the casino where there's a land?
I don't know, but
They're
they just
popping up
announced it the
everywhere.
other day. Yeah. There's yet demand out here for another Sun City.
Baby boomers,
Yeah.
right? They need more places to live.
Yep.
Juries are gonna be quite interesting.
Mm-hmm. Can't wait.
No, I'm just gonna leave that alone. Okay, so now we get into our last area of land sale contract, right? So land conveyancing, purchase and sale of real estate. Each conveyance of real estate consists of a two-step process, right? The first step is the land contract. The second step is going to be the closing. And what becomes the operative document at closing? The deed, okay?
We'll get to that.
Right, we're not gonna worry about that. I just want you guys to understand the two steps that we're gonna be going through. I believe we just got through risk of loss and equitable conversion.
Yeah.
So, when we talk about land sale contract, what is another major issue that comes up? Statute of frauds, right? It will never go away. Land contract must be in writing, signed by the party to be bound, or the party against whom enforcement is sought. It must describe Blackacre, must state consideration, and you must identify, circumstances when the land in the contract is more than the actual size of the parcel. The one exception to the statute of frauds is the doctrine of part performance. So, if there are two of the following, the doctrine is satisfied and equity will decree specific performance of an oral contract for the sale of land. Do you think courts like dealing in the doctrine of part performance? No. So, buyer takes possession, buyer pays all or part of the purchase price, and or buyer makes substantial improvements. Which ones do you think the strongest are?
Possession and
Pays all.
What kind of payment?
Oh.
Partial payment strongest?
I would say that, well, yeah. no.
My rule was payment of all or part of the purchase price. So I'd say possession and payment of all, right? If you're gonna get into the payment section, that's the ideal for saying this is a land sale contract. Because what's the issue of partial payment?
Right.
I was pointing at him.
Oh, I'm sorry.
It's okay, you were looking down. I know. She's probably like almost nodding off and then said, right. Okay. So, I know, it's just so good. I'm just never gonna let it go. All right. So, everybody's like, oh, it just makes me happy. All right. So, that being said, you do want to discuss the issue of rent, and that's going to be factually driven, right? Because it's on a monetary basis. Is it $1,000 a month, or on a $200,000 property? Is it $100,000 and then, or $50,000 increments, right? That's going to be something that you need to consider. The other area, possession is really not the strongest point ever on its own, right? That's why it requires two of these. Because anybody could go in, a renter could be in possession, a visitor could be in possession, right? Somebody squatting on the property could be in possession. But the last one we talked about is substantial improvement. So I think I gave the example. You can go and, rake up the leaves, sweep the front walk. Those are all things that are improvements, but we're talking about substantial improvements. Did you repaint the house? Did you go and fix the fence that surrounds the entire property? Did you rebuild the barn? Whatever the case may be, right? Did you put a new roof on? A bunch of different things that we can use to give example. If you went out and you planted a few flowers, well, I don't know, how significant were they? What was the investment in money for the flowers? That's something to consider as well, right? So,
Things owners do,
yeah,
not things renters do.
right.
That's always where you kind of stuff.
Now, to be fair, look, I wanted a nice place when we rented. When I was in law school, I wanted to have a nice place, so we took care of where we lived, but at the same time, I wasn't gonna go and make any massive investment in the property that we were gonna be in for a short-term period, right? Because it was a rental situation. I don't think we could have argued that it was a purchase situation, right? So, that is the exception to having the written contract. Again, not something that the court really likes. They also don't like revising contracts. They'd rather rescind a contract than revise it, right? Okay. Home stretch here, folks. Home stretch. All right. The doctrine of equitable conversion. I gave you the example of the dad who has the son and the daughter, right? And he passes away. So equity regards as done that which ought to be done. Once the contract is signed by the buyer, they own the land subject to the condition that he pays the purchase price at closing. The seller at the time of execution of the contract now has an interest in the money. Okay? Does anybody have any confusion about that? This is something that is triggered at the execution of the land sale contract. This is not triggered at closing. These are the things that occur between the execution of the contract and the closing date of escrow. Now, one important result flows from this. That's the issue of destruction. So this is under risk of loss category. If in the interim between contract and closing, Blackacre is destroyed through no fault of either party, that's very important, through no fault of either party. And I think I gave this example, the fires that we had a few months ago. You know that some property that was destroyed was in the middle of being purchased, right? I mean, just probability is that there had to be some properties that were in the middle of sales. At the point that buyer signs that contract, it's now his problem. So who do you think should have insurance? Buyer, right? So if this is destroyed through no fault of either party, buyer bears the risk of loss unless what? Unless what?
Unless the seller potentially.
How do you show your intention?
Well, it's a contract, so what can you do? Think of it that way first.
You preach.
No. Step back, guys. It's buyer's responsibility unless what?
The contract states otherwise.
Unless the contract states otherwise.
Right. So you agree otherwise.
So you could say, that's okay, we already have homeowner's insurance on the property and fire insurance, so some type of insurance that way. We'll just carry that, but if something happens to the property, then we are paid out for that property, not you. Now, you probably need to have some other caveats, like then the contract is therefore invalidated, or it's terminated, or there's some frustration, not frustration on purpose, but more of like an impracticability.
Maybe.
So
Possible.
So what you're looking for there is the general rule is that the risk of loss is on the buyer unless otherwise contracted for. That's all I've got, unless y'all have some questions or Professor Drucker wants to add anything. But I think we covered it all. It's only been a few weeks, so I know.
I'm 0 for 4 tonight. I haven't even seen Friends, so I'm getting out.
Gosh, you're killing me.
It's, Old Man Heckles.
Heckles? Yeah, that makes sense.
Yes.
You Googled it.
No, I watched
She
that
got
show.
so offended right now when I said that. Oh my god, I love that.
I'm like, that is one show I did watch religiously.
I have one question. With takings, there were some cases we talked about that, when, I think it was in the realms of takings, when, say, the party was applying for,
We get some building permit or something of the sort, and it was a condition that in order to.
That sounds like more of a zoning ordinance issue.
I think you're right. Yeah, it was like a condition proceed, like we'll give you the permit if you give us this easement on your land or whatever.
That's an exaction.
Okay, that's an exaction, okay.
Uh-huh. That's the you scratch our back, we'll scratch yours. If you give us, or if you do this for us, then we'll go ahead and do that. If you want a permit to build on the land, that was the one with the plumbing store, whatever, right? If you give us the permit to build or expand, as long as you give us the 10 feet along the front area for the bike path,
Right,
we'll do that.
Nolan and Dolan.
Right.
Let's look up those two cases.
Those are exaction cases.
Very good.
With variances, I know the more the better, but what if it's a situation where a number of people have requested or asked for a variance, but have not been successful, and then you come along and they finally say, okay, we'll do the variance. Did that happen?
Sure.
That has to happen at some point, right, when they.
It doesn't have to. Maybe nothing meets the criteria of what would be a variance to that zoning law. But yes, it could be that other people didn't quite have the,
Money.
reasonably, but, or like realistically, but, maybe they didn't have the proposal that they were looking for that really, still kept the spirit of the zoning ordinance without completely breaking it. Maybe that's what they wanted. They wanted something, bless you, wanted something that was close but not exact, bless you.
Thank you.
So yeah, it could be that a number of people have been denied and then somebody gets a variance granted. That's gonna be very factually driven if there's going to be, prior attempts that are of similar nature. You're gonna have to look for what the differences are.
Yeah, if you don't see it, I mean, it's interesting because again, it's.
I hate to say how they vary.
Yeah, it's kind of beyond the purview of this class, but something had better changed with the land. Something about the situation of what's going on had better changed because you really aren't allowed to pick and choose. You can't say, well, I like this person, I don't like that person.
Right.
This is not relative. This is not a rationally related act. So it doesn't pass constitutional standards. So the only time you really see, it's not like you never see that, but what happens is you see a community gets bigger and bigger and bigger, and all of a sudden the needs of the community change, the land changes in some way, and then all of a sudden it becomes like, it's only a matter of time. And that's when you start to get those kind of variances where they keep saying no, 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 and then all of a sudden gets one. But the whole idea then is like, I'm gonna say, well, what the heck, we're gonna turn that area into this anyway. And then what do they do, by the way? You're not gonna sit there and do variance after variance, right? So what do?
And then.
Yeah, you just make it amended and move on, you go, really in the real world, this is good, it's all true. But, they have things like you can also make a contract, believe it or not. That's code for liability. But you can make a contract with somebody that because they're this special.
You can contract with somebody to help them get your kid into college, apparently.
So,
At your own peril.
at least they're not murdering teenagers for, cheerleader spots anymore. So that's good.
Oh, I know. Texas.
Yeah.
That was a great Lifetime movie.
Yeah. And that was really, I saw that one. 1 but anyway, so, you see in the real world, you see a lot of different stuff. You see things called floating zones, which means that there's zones that they can actually just put wherever they want. You have things that some are just undesignated zones. They want to wait and see what happens.
See how the community evolves.
And so there's lots of different, tools that they have at their disposal. And, really the only real constitutional barrier is the only thing they have to jump over is that what they're doing is reasonably related to a legitimate governmental interest. How high is that? So you really got to go.
Well, that's in the category of levels of scrutiny. Where does that fall?
Yeah, we talked about levels of scrutiny. Yeah, we did.
Falls at the bottom.
That's way down there. Yeah. Remember the case about the home for the kids that was across the street? It just has to be rationally related to legitimate governmental interest. So it's not a high standard. You'd be surprised how many times they try to do things that are kind of, but that's really, they have a lot of different, sort of weapons at their disposal, so to speak. But, in this class, you do learn the basics, and this is how it kind of works, and every city works kind of the same, except, quote unquote, the ones that don't, the ones that try to close themselves off and things of that. There was a case the other day, I don't think we discussed it in this class, again, another amazing case, just to show how these things happen. There's a city, I can't remember the name of it, but it's in Orange County. And they were asked to go ahead, and somebody wanted to put like some kind of a public service in there. And their defense, okay, you ready? This is a really small place, it's only like a mile. Their defense was, we're exempt because the only thing we have are $1 million homes in this square. That's all we have. That's our defense. Who won?
Was it Kodo?
I think that was.
Yeah, Kodo de Casa.
Yeah.
If anybody ever watches Real Housewives of
Yeah,
Orange County.
yeah, they
That's
said
where
it was
Vicky
really Real
lives.
Housewives
Yeah.
did it. They won. They won because this is a very unique neighborhood where all of the houses are $1 million. Now compare that to some of the stuff that we saw about, college students, in apartments, very small area, same kind of thing. But those tend to lose. But they actually won on that defense. Of course, they're always $1 million houses.
And at this point, by the way, familial zoning is really just not gonna fly. There are so many, that's like you see the show Modern Family, right? Families come in all shapes and sizes and all, descriptions. So I think it would be so difficult now for them to try and create some kind of restriction based on, the makeup of a family.
I mean, there still are some. I mean,
Yeah.
it's funny because I know some in Redondo Beach where you can't like have fat and things like that, some of the beach houses, but there's things but they're pretty hard.
Yeah.
And they certainly don't ban them on familial grounds anymore. They ban them because they're loud and noisy and obnoxious and whatever they want to do. That's a better move at this point, that's all I'm telling you. So, but I don't like you is never a good basis, just so you know, right? If you look at a statute, it never says, I know what you're saying. You don't like them. Except in Orange County. Like that's
All right, everybody good? Questions? No? Absorbing? Trying? I know.
okay.
Caffeine shrinks the capillaries and then you can't absorb everything as fast.
Just think it's all downhill from there. This is the last of the difficulty. The deed's the last thing that will be difficult. Everything else that passes.
Recording.
Well, yeah, recording. Okay, I take it back.
Sorry.
Yeah, that's true.
Nothing will be as difficult as fee estates
Yeah, nothing.
and the rule against perpetuity, so it's all downhill after first semester.
That's true. I think we're in
I didn't mean to
home
like
stretch.
burst the bubble right there in front of you, but we're gonna be just fine, everybody's gonna make it just fine.
Think about it after midterms, it'll be like, after that next week, we'll have another month of school.
Yep.
Jeez, you're right.
Goes fast.
Yep,
Today.
enjoy, good luck, remember our rule is we won't talk to you after this.
That's right.
I mean, like, pleasantries exchanged are fine,
Yeah, I mean, we'll talk to you.
don't hate us.
Okay, we good? All right.
Thank you.
So far, so good. Good job,
I
people.
was totally gonna share something after class, and I totally forgot what it was now. Must not have been that fun.
Oh, this kind of thing, saying-
As requested, the brief book is back.
Oh, yes, put all your briefs in there if you have them.
Now I just threw it in the back of my trunk. I don't think I have a
Good luck, everybody.
Right.
Remember, outline and move on after an hour. Please just hear me this Saturday. Outline and move on after an hour.
I know.